Hi there, I'm Savannah Mexto with Mannor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Mannor. On today's webinar, Bob will be taking it back to the basics with Wills and Trusts 101. What are they? What's the difference between a will and a trust? And most importantly, do you need one? Now, before I pass the torch to Bob, I'd like to cover a few housekeeping details. First, a quick disclaimer, and Bob will cover more on this later. Today's webinar will be informative, educational. You'll definitely learn something new, but you're not going to receive unique legal advice. I encourage you that if you are looking for unique legal advice specific to your situation, to contact us after the webinar. Also note that today's webinar is recorded. If for some reason you get pulled away or distracted, don't worry about it. We'll send out a replay link tomorrow after the webinar. Now you can also share that link with family and friends. Now, if you have questions today during today's webinar, I encourage you to use the chat box. We will save time at the end of the webinar to review questions. If for some reason we don't get to your question, we will contact you after the webinar. Now, why should you listen to what the folks at Mannor Law Group have to say? First, note that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Mannor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He's currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, Mannor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Mannor.
Better turn on my microphone there. Hi folks, how you doing? As Savannah said, this is intended to be a back to basics presentation. So we're going to talk about wills and trusts, and we'll get into some other issues, but really kind of just dig down into wills and trusts and how they work and how they don't work and why they're important. So let's get right into it. This is a graphic I've used for some time now to distinguish the different types of legal documents. And it's really important to understand that different documents do different things. So it's extremely common that people will call and they'll say, well, I need to get my will done. Well, that's great, you know, but one of the things when somebody needs a will, they really need more than just a will. A will only covers a very small portion of things. But I was talking to a reporter, they're doing an article on estate planning, and she asked me about wills recently, and I said, you know, with a comprehensive estate plan, often the will is actually the least important document with a very thorough estate plan. Now, that's not always the case, but in probably most of the situations, the will is one of the least important documents. And it's fine for people to say, hey, I need to get my will done. You know, it's just kind of a generic term to incorporate all of the different things. But the reality is, it is important to distinguish the different documents and why they're important and how they work differently. Because when the time comes, you're going to be called upon to use these documents. And so what do I mean when the time comes? Well, if you know, the person that you're appointed to help, whether it be under a will or under other legal documents, if they get sick, if they die, you're going to need to know what document to use when. It's actually one of the things I think is probably one of the more important things to understand, because so many times I've had people go into the bank with a legal document and say, oh, those legal documents don't work, the bank won't accept it. And sometimes it's true that the bank's just giving you a hard time and giving you the runaround, but sometimes it's because you brought in the wrong document or you didn't understand what it was that the bank really needed. And the bank's not going to probably tell you, oh, no, we don't need that document, we need this other document. Sometimes they might just say, hey, we need a court order, which usually you don't. I mean, we usually try to stay out of court. That's not something that we're encouraging people to do unless it's absolutely necessary. But we'll often hear that people went to their financial company or their bank or even the hospital and they'll say, they'll bring in a legal document, and it turns out that they'll say, oh, well, we can't accept that. We need to get a court order. We need to get, something signed by a judge. And that's not true. Most of the time, that's not what they need. It's just the document in front of them is not going to be sufficient. And that's why it's so important to understand how these documents work. So we have this divided, as you can see, into lifetime and after death, right? And so we've got these lifetime documents and processes, and we've got these after death lifetimes and processes, and we have a little bit of overlap, okay? And so this is really important to understand what document to use when. This creates a good portion of the difficulties that people have when they are trying to get something done, whether it's for a spouse or a parent, or this is for you, and you've appointed somebody else to help you in illness or after death. And if they don't know which document to use, often they just get the runaround, and they end up feeling like they have to go into court. And I've had that happen so many different times, where somebody had perfectly good documents that could have been used, that could have kept them out of court, but they brought the wrong document. They were told, no, that's not going to work, you got to go to court. And they went to court, and now we're in the court system, and we're going to have a judge appointing who makes decisions and things like that. And that's fine if that's what you want. I mean, sometimes that's appropriate. But many times the whole point of someone having gone to their attorney and getting these legal documents in the first place was to stay out of court, to keep the family matters in the family. And really self-determination, that's one of the big things, is really self-determination, because the person that signed the legal documents that went to the attorney, ideally, if that process went the way it should go, they were being self-determinative. They were making their own decisions and saying, well, this is the person I would want to help me. This is the person I trust to make medical decisions. This is the person I trust to make financial decisions. I'm empowering them through these legal documents. Now, we all know, sometimes people get down on attorneys because attorneys can, sometimes those experience with attorneys isn't as great as we'd like it to be. And I do hear stories sometimes where people went into their lawyer's office, and the lawyer, shoved documents in front of them and said, sign here, and they don't really know what they have. They don't know really what it does. Well, that's not how it should work, right? That's not good. And so the idea is we want to not only have the right documents, know when to use them, but the first step is, of course, making sure that you're getting what you want, that you are making your self-determination, that the attorney is just assisting you with that, not pushing you one direction or the other, or the kids, frankly, pushing you one direction or the other. It should be your self-determination, and that's what the documents allow you to do, is make decisions for yourself for the future, even after you might become sick or incapacitated or after your death. It's you making the decisions rather than leaving it to a court to decide who's going to make decisions for you, okay? So we're going to go through the court process, and we're going to go through the legal documents. So you see we've got the lifetime and the after death. So this is Wills and Trusts 101, so I'm going to kind of focus on those, but the idea behind Wills and Trusts 101 is you can't do those without talking about what I call the lifetime documents too. To me, so many people focus, in fact, in law school, that's really kind of what they focused on, and so many lawyers, that's what they focus on, is what happens when you die, right? And that's important, of course that's important, but more important is what happens before you die. What happens if you don't die? Because so many of us, and this isn't really something that a lot of us like to think about, but the vast majority of us in reality are going to face some period of time before we die that we're going to need the assistance of somebody else, whether it's the physical assistance of somebody else. But to be honest, the vast majority of us are going to need help making decisions, somebody else helping us balance our checkbook, somebody else helping us make decisions. Now, I get it. We don't like thinking about that. A lot of us have this idea in our mind that, well, that might happen to my mom, that might happen to my brother, but that's not going to happen to me. I'm always going to make my own decisions. I'm going to die with my boots on, in my own house, in my own bed, and I'm going to be making my own decisions until the last second of my life. Well, hopefully, right? That's the goal. I'm just going to tell you that's not what usually happens. That's not what usually happens. And so in addition to talking about wills and trusts and what happens after death, we really need to talk about those documents also, even from a beginner's perspective, of what happens before you die. So I'm going to start with the after death, because wills and trusts, people kind of think about it. Well, what's going to happen when I die? Am I going to pay taxes? Am I going to, who's going to be in charge? Is it going to go through probate? All those types of things. So we're going to start with after death, and we'll come back to the lifetime. I'm doing it the opposite of the way I usually do it or explain this. So what happens with the will? So when does a will take effect? Well, you probably know, and you can see from this chart that the will does not overlap into the lifetime section. And I think intuitively you probably knew that. The will does not take effect until after death. But what a lot of you probably know, and some of you might not, is the will still doesn't take effect. Even after death, the will doesn't take effect. The will takes effect after a probate court issues something called a letter of authority. So a letter of authority would be the first action taken by the probate court after it's reviewed the will. The will's been filed with the county probate court, and a petition has to be filed. Now that petition can be filed by a family member. It can be filed by a creditor, meaning you owe money to somebody, and they can file a petition to open up a will. And then the will, if we have a will tell us who is the person that you want to be in charge. Sometimes we call that the executor. The probate court actually calls that the personal representative. They don't use that term executor anymore. I still use the term executor because it incorporates more than just probate, right? The executor is who handles the estate, whether it's in probate or out of probate. But in probate, they call it the personal representative. Is the person that you've appointed in your will going to be the one that is the executor or the personal representative? And the answer is maybe, because a judge has a say in that. Now the judge, there's a couple different things. There is, of course, that's the priority, the person appointed in your will, but they have to sign an acceptance. So the person that you have appointed has to sign something saying, I accept, I will act as the executor or personal representative of the will. And then different judges and different courts have different standards as to who can serve. And so some judges will say, well, if you have a felony, I'm not going to authorize you to be the executor. I'm not going to authorize you to be the personal representative. And so different courts and different judges might have different rules with regard to that. Also, family members or creditors can argue with the judge. They can file a petition with the judge, with the court, or they can object and try to have that person you've appointed removed because of cause. In other words, they can go before the judge and say, Judge, this person shouldn't be doing it because of, and then finish that sentence, right? But what I want to point out for those that don't know is that you might have the most well-drafted, most articulate will in the world, and it still goes through probate. Okay, the will doesn't work on its own. Always the question you have to ask when you're dealing with laws was, how do we make it so? How do we make it happen? Because just because something is in writing, just because something is legal, doesn't mean we get to snap our fingers and then it happens that way, right? Now, there's got to be a process for that. Well, we're going to talk about trusts in a minute, and the trusts are where it's more where you're pre-authorizing, you're pre-setting this up, you're making it, you're empowering the executor before you die. The will doesn't do that. The will says, this is who I want the judge to appoint, all right, as my executor. And the judge, the probate court, it's a fairly automatic process. There's no reading of the will. There is no where the judge is probably even looking at the file. It's a fairly automatic process. You don't even show up in court. There's not even a hearing in court to appoint the executor. It is all paperwork, all right? And then if nobody objects, but if somebody objects, then there could be a hearing and things like that. But that's how that works. When you file the will, somebody would file a petition to initiate what's called a decedent's estate, and that's how that makes the will effective. And then somebody is appointed, the judge. In fact, this might be interesting to some people. The judge often never actually signs it or even touches that file, because the clerk of the probate court has the judge's signature on a stamp, and often it's just the clerk stamping that form appointing your executor, and the judge never looks at it or files it. And so the only time the judge is really going to get involved or there's going to be a hearing is if there's objections, if people are arguing about it. Well, what if you don't have a will? If you don't have a will, same thing happens though. It's oddly, a lot of people think, oh, I need a will to avoid all this court process. No, it's exactly the same process, except the state of Michigan has written a will for you. It's called intestate succession. So the state of Michigan then says who would be your executor. And there's priorities, okay? So they say, well, this class of people, meaning like spouse or children, they have the first priority. And in order for that to happen, then we have to have the other people in that same priority level either agree to it or not agree to it. So they can agree to it and they say, okay, yes, we're going to have Susie be the executor for mom. And all of the kids, there's 9 kids, all 9 kids will sign off on that. Or they don't, and then we go through a separate process. If they definitely disagree, then there's probably going to be a hearing, and that's when the judge would actually directly get involved. So how's that different than this middle section? And why does a will have to go through probate and a trust doesn't? Well, here's the thing about a trust. The trust is actually set up during your lifetime, okay? And so the idea behind the trust is you're actually setting up to say, this is a contract between myself and those that I love and those that I'm, my family typically is what you're saying. And so you're setting up a contract now during your lifetime. That's why they call it a living trust. You may have heard that term, living trust. You're setting it up during your lifetime, and you're prearranging your accounts and your house and your other investments and your life insurance. You're prearranging that with each of those companies to say, see, I signed this contract. I want you as a life insurance company to follow the terms of this contract. I want you as the bank to follow the terms of the contract, you as the credit union to follow the terms of the contract. But you set all that up during your lifetime. And so then after death, we don't have to go through a court process because we've already notified the bank. We've already notified the life insurance company. We've already notified the state with regard to your house. We have a new deed that says that the trust contract is going to be operative. And so the will can't do that. So if you die and mom has a will and mom dies and the kids get together and they say, okay, we're going to sell the house. The will says Susie's the executor, and Susie takes that to the realtor to say, hey, let's put the house up for sale. The realtor is going to say that will doesn't have any effect. I can't do anything without a court order. Whereas with the trust has already made it so that that house is subject to the trust because we filed a deed with the county. So the county and the world knows that the trust is in charge. With the will, just filing the will doesn't make it the executor's in charge. For the trust, it does. It's just the difference in the way it works. So a trust, if you want to think about it, it's a contract. You have prearranged all of this stuff. It's like prearranging your affairs. You prearranged all of this stuff. A will is just sort of a catch-all that says, here's who's in charge and here's who gets what. But it is basically invoking the legal system. The will invokes the legal system. The trust says, I don't need that legal system because I've already prearranged all of these things, okay? And so we're going to get into a little bit more, and I'll give you some examples of how do we incorporate the assets into the trust. But the idea behind it is some people will hear this part and they'll say, you sound like a smart guy, Bob, but my mom had a will and we didn't go through probate. And what I'm here to tell you is then the will didn't matter. The will did not matter. If your mom had a will and you didn't go through probate, the will didn't matter. What I mean is there was some other mechanism for those assets to transfer, and the will had no value. It did not have any legal effect. Now, some people say, well, the will said to divide it 3 ways, so we divide it 3 ways. If you didn't go through probate, there was no legal obligation to divide it 3 ways. Okay, there would have been some other mechanism. So let's talk about these other mechanisms. Transfer on death, payable on death, beneficiary designations. Okay, all of these, most people are most familiar with beneficiary designations as it relates to a life insurance policy, right? You get that idea. Somebody has a life insurance policy. It says it's going to pay $50,000 if George dies. It's going to pay $50,000 to his daughter Susie, right? And we get that. So George is the life that it's based on. Susie's the beneficiary, okay? And so that doesn't need a will. Now, what a lot of times George thinks is George signed a will saying that Susie's going to divide it between her 3 siblings. Susie has no obligation to divide it between her 3 siblings. And in fact, if Susie does the right thing, it may cause her some tax problems. If Susie tries to follow the will, when George didn't follow the will, George just listed Susie as the beneficiary. Susie may end up, depending on the type of account that it is. So we got to talk about what they call qualified funds versus non-qualified funds. But the bottom line is, with certain assets, if Susie tries to follow the will without the asset actually going through the terms of the will and going through that court process, it could cost Susie substantially in more taxes. And often what they do is they choose, George would have chosen Susie because George figures that Susie's the most financially responsible. Well, most financially responsible, sometimes that means that Susie's in the highest tax bracket. So we might end up having to have where Susie's paying taxes on those assets, depending on if it's what's called a qualified fund, and we're not going to get that deep into it this time, but I'll just give you an example of that. So Susie is listed as the beneficiary on a qualified annuity or something like that, and Susie's job, at least in George's mind, is to divide that up between her 3 siblings. Susie's going to get hit with a major tax, and the other kids won't. And it could have been that the other kids were in lower tax brackets, and we could have actually paid less to the government altogether. And it all happens because George, Dad, said, well, I'm just going to, list Susie as a beneficiary. So beneficiaries can work sometimes, but they're often not the best answer, especially if you want to have an executor. And people think, oh, well, just signing that will, that's going to make it so. It doesn't make it so. The will has to actually go through court. So with the trust, and we're going to talk about trust, and we're going to talk about trust specifically as it relates to these things I was talking about before, we call qualified funds, meaning tax-preferred funds like qualified annuities, IRAs, 401ks, TSPs, PSPs. There's all these different types of accounts that are tax-preferred, Roths, that is going to make a big difference in how they're going to relate to the trust, because there's a substantial change in that we're going to discuss in just a minute here. But before we go on to that, I really think we need to spend a couple minutes on this lifetime circle. So very important is to know that all of these will transfer on death, payable on death, beneficiary designations, none of that makes any difference during your lifetime. So what's as important to me, probably more important to me, and what I'm encouraging the people I talk to make it important to them, is not just what happens when you die, but what happens before you die, because you might get sick, you might have memory issues, you might have a stroke, you might get dementia or Alzheimer's or Parkinson's or any of the dreaded things. And boy, oh boy, what if we have that and all we have is a will in place or beneficiary designations in place? That's going to really create some big problems. So what some people do, and you'll see in a second, I'm going to tell you absolutely don't do this. So that's why it's not on this chart. Some people say, I'm just going to add my kids' names now. It's a really bad idea. I'm going to tell you, do not add your kids' names to your house. Do not add your kids' names to your bank accounts. Do not add your kids' names to your investments. It's a really bad idea. It causes big problems for you and for them, okay? And I'll explain that in just a second, but I'm telling you that's why it's not on this chart. You see nowhere on this chart does it say adding kids' names, right? So the only thing that we have on this chart that covers both lifetime and death is these trusts, which I've explained a bit, and I'll go into a bit more detail in just a couple minutes here. But before we do that, let's talk about what if you got sick. And the truth is, the vast majority of us, I'm not just saying 20%, 30%, 50%, the vast majority of us, most of us, are going to face some period of time before our death where we can't make our own decisions, where we are dependent on somebody else to make decisions. And so how well have we laid that out? Okay. And so it might be a day, it might be 6 months, it might be a year. I can tell you even 6 months can cause all kinds of havoc for the family if we don't have these things in place. So for a lifetime, we have a durable power of attorney for financial matters. If we don't have that, we might have to go into court and get control of those assets through a conservatorship. Now the judge appoints who's deciding about money. If we are unable to make our own healthcare decisions, say we're unconscious or we have severe dementia or Alzheimer's, something like that, we're unable to make our own decisions for healthcare, then In advance of that, we would have signed a healthcare power of attorney, sometimes called a patient advocate or a healthcare proxy. But whatever you call it, that would be that you've appointed somebody that you trust to make decisions only if you cannot. Now, these are two separate documents. The durable power of attorney and the healthcare document are two separate documents, and they must be separate documents in Michigan. They must be separate documents in Michigan. So many people think there's just one document that covers financial and medical. That's not true. They're separate documents, and they have to be, because there's different triggers that make them work properly, okay? And so if you don't have a healthcare power of attorney, and we need to make decisions about your healthcare, and you're unconscious or you have Alzheimer's, even things like end of life and life support decisions, then if we don't have that healthcare proxy or healthcare power of attorney, we might have to go into court and get a guardianship, okay? There was a lot of news stories in the last few years about court-appointed guardians and court-appointed conservators who were appointed by a judge, and they were strangers. They were companies. They were businesses that were now appointed as the public guardian, even though there were family members that were willing and able, okay? And so instead of appointing the family members, they appointed a third party, a stranger, or a company to be the guardian and conservator. There was one particularly well-known case where there was a married couple, and they had appointed their daughter and stepdaughter, or the family had wanted the daughter and stepdaughter to be guardian conservator for both of them. And when the daughter and stepdaughter went into court, the court said, no, we're going to not appoint the relative. We're going to appoint this attorney or this third person. It wasn't an attorney. It was a public guardian. And so there's really good public guardians. I'm not going to say there's not good public guardians. Absolutely really good public guardians. But there was this case, and there's lots of other cases like this, but this one in particular, the judge appointed as public guardian over a family member. Public guardian then spent close to $500, I think it was like $400,000 in a period of about 6 months, hired her husband as the attorney for the estate, hired her own healthcare company, as she had a home care company, hired her own home care company that she had a profit interest in, and spent $400,000. And then to make matters worse, she thought that the family, the daughter, stepdaughter lived right next door, and she thought she was getting too nosy and asking too many questions. So she put up a privacy fence 365 degrees around the house so the daughter couldn't even see across the yard to see what was going on. Such a crazy case. It got so much attention that the governor of Michigan and the attorney general actually got involved. That guardian was removed. It's still a separate guardian. It's still not, it's now a new person, but it's not the family. And it was just a messy case. In fact, the governor and the attorney general opened up a elder abuse task force, largely as a result of cases like this, to deal with guardianship reform. So it's just one of those things, and that seems like a crazy case, but the idea of if we have people we love and trust, why wouldn't we want them instead of a judge making those types of decisions? Okay, so that's really important. Trust can work in that too. The nice thing about trust and having that contract, the trust contract, is that we can incorporate both lifetime and after death. And you're still in charge during your lifetime as long as you're alive and well. But then we incorporate the, what if you get sick? What if you have dementia? What happens when you die? All in that. All right, so this is kind of the big picture. I just mentioned earlier, don't add your kids' names to accounts. It's a bad idea. Why is it a bad idea to add your kids' names to accounts? Well, do kids ever have any financial troubles? Because if they have financial troubles and their name's on your accounts, guess what? You now have financial troubles. Their financial troubles become your own. If they didn't pay their credit card bill, credit card company sues them, they get a judgment. You don't even know about it. They may not have even told you about it. They can come and garnish your account because their name's on it. If their name is on your account, then they own it just like you own it, okay? And so they own 100% of it, at least under law. If you can withdraw money from it because your name's on it, that means you can withdraw all of it and they own it. And so any of their financial problems, you say, but my kids are doing well financially, they'd never do that. Okay, well, do good kids that are doing well financially ever have divorces? They get divorced. That could be, brought into as part of the divorce because it's considered their asset. The kids that are in good marriages and financially stable ever get sick, or do their spouses get sick? Because when somebody gets sick, their medical bills, you could be responsible for their medical bills. So one of the things we talk about sometimes is nursing home costs, right? It's something I talk about a lot, is protecting your assets, protecting yourself from nursing home costs. Well, what about if your kids' names are on your accounts and they go to the nursing home? People think, well, my kids aren't going to go to the nursing home for I do. It happens, right? It certainly happens. And so if your kids' names are on your accounts and they go to a nursing home or their spouse goes to a nursing home, your accounts could be subject to that. Right, so don't do that. Also, quitclaim deeds and ladybird deeds. Often these are not the best option. Quitclaim deeds in particular, but also most of the time ladybird deeds. Ladybird deeds are kind of like a contingency deed that says upon my death it'll transfer. If I haven't done anything else with it, it'll transfer to the kids. But both of these, I think, come with big problems. There's a lot of attorneys that use ladybird deeds instead of wills or trusts. My opinion is that's not a great idea. There are certain circumstances that we will use a ladybird deed instead of a will or a trust, but it's pretty rare because ladybird deeds do not solve the problem of what if something changes. So it solves the problem of this is how we would want things to go. This is how we want everything set up if we die the instant that we sign that deed. But what if something changes after that? What if somebody dies? What if somebody has some debt? What if somebody has a divorce? What if one of the kids die before the parents do? What if parents go into a nursing home? None of these issues are going to be solved by the quitclaim deed or the ladybird deed. And in fact, with the quitclaim deed, you're going to potentially have some property tax issues. Not potentially, almost certainly have some property tax issues because your home probably has that homestead or personal residence exemption. You sign the quitclaim deed, you might have lost that, even if you haven't filed the deed. So a lot of people will sign these deeds and then not file them until after death. Guess what? They will see when it was signed and they'll go backwards and charge you additional property taxes and penalties and things like that. So the idea is these are occasionally a planning technique, usually not quitclaim deeds, almost never. Occasionally a ladybird deed can be appropriate, but my opinion, and other attorneys will disagree with me on this, but I am fairly adamant that ladybird deeds are often not only not the best choice, but often can cause more harm than they cause good. Okay, people think, okay, well, it's about avoiding probate. Great, that's an important thing. We want to avoid probate, but we also want to protect the house from the nursing home. We also want to keep our property taxes low. We also want to make sure that it actually does avoid probate. And if people die in the wrong order, it's often not going to avoid probate. We're going to want to make sure that in the event that one of our kids dies, that the distribution of the house is still going to go properly. Do we want it to go to the surviving kids, or would we want the child that died to still, their family to still get a share of it? Okay, there's all of these issues other than probate avoidance. When we focus on one issue, when there's actually 10 issues that are involved, we make big mistakes because we're focused on probate avoidance. That's important, certainly. Probate avoidance is important, but there's all these other things like not losing it to a nursing home, like not not having people die in the wrong order, those types of things. So bottom line is, I'm not a big fan, certainly almost never adding kids' names with a quitclaim deed, but often I think that adding kids' names with a ladybird deed is also not the right answer and often causes more harm than good. All right, so just a quick recap here. If you've planned, you have a durable power of attorney for health care. If you haven't planned, we might have to go to court and get a guardianship. If you planned, you may have a durable power of attorney for finances. If you haven't planned, you might have to go to court and get a conservatorship. Well, I don't have to worry about that because I got payable on death on all my accounts. I don't have to worry about that because I've got all my kids' names on my accounts. Well, we talked about why that can be a problem. That could be putting your money at risk to what I call the 4 Ds. Divorce, your kid's divorce. Now your money could be exposed to that divorce. Debt, your money would definitely be exposed to your kid's debt potentially. Disability, one of your kids or their spouse becomes disabled, has medical expenses, needs nursing home, needs home care, needs assisted living, needs round-the-clock care. You know, that's not going to be covered by Blue Cross most of the time. That's not going to be covered by Medicare most of the time. We've got to look at Medicaid and some other programs out there. But if we potentially your money, if your kid's name is on it, could be exposed to their health issues, and then death, of course, people dying in the wrong order. I want to go back. I was just thinking about this just real quick on this deed issue. So a lot of people, they still really like the idea of these deeds. And so I'll give you, I did another presentation, you can go back and watch it, about deeds and how often they cause, there's mistakes on them. Both deeds prepared by lawyers and particularly deeds not prepared by lawyers. I had one I saw yesterday, which was, seemed logical, okay? The law isn't always logical. It seemed intuitive. So they had a deed. So, and I don't know exactly the family situation. I just saw the deed. I haven't had a chance to talk to the family, but it appeared that the two brothers had inherited a property together, probably from mom and dad. They probably did it on a deed or something like that. So then at some point, let's say we've got George and Leroy, and so Leroy says, you know what, George, you use that property, I don't. I'm gonna deed my half to you. So what did the deed say? Leroy signed a deed that says, and it was a proper form. It was a proper quitclaim deed, and it said, from Leroy, I'm deeding my half to George. Well, because of the original deed where George and Leroy got it, that's not proper wording, because Leroy was just saying, I'm deeding my half to George. Well, what that meant, because of the way that the original deed said, so you can't just look at the deed on its face, you got to look at the previous deed, and it meant that George was deeding one half of his one half to George, because he said, I'm deeding my half to George. Well, the actual legal effect of that was Leroy's deeding a quarter of it, because he owned half and George owned half, and he said, I'm deeding half to George, and so now Leroy still owns a quarter of it. And in fact, it actually put a cloud on title. Not only did it mean that Leroy still owned a quarter of it, it created a cloud on title, which is the way the title folks say is you can't sell it until you fix that cloud. Until you go to court and fix that cloud, nobody else is going to buy it. And this happens all the time. And that's just one example. And you can watch the video from, I did a webinar Wednesday a couple weeks ago on deeds and all the mistakes that people make on deeds. You can go back and watch it. But I mean, we probably see deeds multiple times a week that people have prepared. Sometimes it's lawyers have prepared, but often it's, people think it's a simple document. It is absolutely not a simple document, okay? The wording of your deed, even though it's one page, can cause you all kinds of problems. If you change one word, change one, even sometimes a comma, can be in the wrong place or things like that. So, all right, so we talked about this. Going back to the recap, if you have planned, you have a will or a trust. If you haven't planned, the state of Michigan has written a will for you. They call it intestate laws. Do I need a will? Yes. Even if you have a trust, we still have a will as a backup. This is why I say sometimes the will is the least important document, because often with a comprehensive plan, especially if it has a trust, the will is a backup and really won't get used unless something goes wrong. A will is going to name who gets your stuff and who's in charge. Who's in charge is referred to as the personal representative. A will controls what you own in your own name alone when you die. So it does not control things that have a beneficiary designation on it. It doesn't control anything that has a joint owner. But we talked about some of the problems with both of those. A will must go through probate. A will has no legal effect without going through probate. It's going to be probate. Decedents' estates are open a minimum of 5 months, but typically closer to a year. Controls with the probate court, not with the family. And everything in there is a matter of public record. Oops, I went the wrong direction here. What about a trust? So it could sometimes refer to a revocable living trust, meaning a changeable trust that you create during your lifetime, revocable living trust. It does avoid probate, but only for those things that we put in. So you'll see my pictures on the sides here. In this one, I have the picture of a funnel. The will is a funnel. Why is it a funnel? Because it will catch It's a catch-all. It catches anything that needs to be caught that doesn't have any other mechanism of transfer, but it funnels it down to the people that would get it, but it funnels it through probate. Okay, whereas the trust, on the other hand, I like to call it a little red wagon, or a wagon or a wheelbarrow, whatever we want to call it, because it works to avoid probate, but only for those things that we put in the trust, that we title into the trust. And so when you have this, you also have to remember over time that as you get new stuff, you got to make sure it's in the trust. You buy a new condo, we got to make sure it's in the trust. Now, that's not difficult to do. When in our office, you let us know that you're buying a condo, you let us know beforehand. We'll give you the wording. When you buy it, it just automatically goes in there. It doesn't cost you anything. If you forget, which people often do, they'll forget. They buy the condo, they forget, and then they realize that they need that in the trust. Yeah, then there's a small charge, very small charge for us to put the condo into the trust. But you can do it yourself as long as you do it as part of the purchase of the condo, and that's free, right? So if you remember, but what about the people that don't remember? Well, that's why the people in our office, our clients, we have this annual meeting for our clients. And the purpose of the annual meeting, and this year it's going to obviously be digital, it's to remind our clients and just to kind of do some memory joggers for them to say, okay, don't forget, if you bought anything new, we got to make sure it's in the trust. If you already bought it, then we're gonna call you and schedule a time to get it in the trust. And there's gonna be a small cost for that, but if you called us before you bought the condo, you could have done it for free. So there's ways, there is some maintenance for a trust. So the advantage of the trust is you now have this contract that's gonna say how you want things to go. You're pre-arranging, pre-authorizing, but that just means it requires some maintenance because as you get new stuff, we need to do it. If something changes with one of the people in it, we need to update it, right? Okay, so it requires a little bit of maintenance, which is why we have for our clients this annual meeting for our clients. It's not a one-on-one meeting. It's a meeting that we have that says, we're gonna walk you through this every year. We put it on video if you can't come to the meeting. This year it will just be video because we can't have a meeting, but the idea is that it's an annual time, once a year. We want you to pull out your trust documents, pull out your will documents, pull everything out. We're going to walk you through them. We're going to tell you about changes in the law that might affect you, and we're going to remind you that, hey, if you bought anything new, got to make sure it goes in the trust, and here's how you do it. Okay. It of course handles things in case you become incapacitated and can't handle it yourself. It does not help you qualify for veterans benefits or Medicaid. It does not protect your assets from nursing home. We have ways of doing that. The trust is not that. The trust is not to protect assets from the nursing home. This is to make it so that it's organized well. It's prearranged. It makes it easier for you and for your family. It makes it easier for you in the event that you become incapacitated or have dementia or Alzheimer's or anything like that. But it does not protect assets in the way that other methods do. Okay. What about after you die? Well, one of the things after you die is we've got Uncle Sam over here wanting your money, right? So we're going to talk about that in just a second, because that rule has actually just changed as of January 1st. So if you're one of our clients, you would have gotten this message in the mail, and we did it by email. We've also now sent it out in the mail about this law change and how you need to now update your legal documents, whether it's a will or a trust or anything else. You got to update your legal documents because of this law change. And so we've sent that out to all of our clients, and we're going to continue to send them reminders and things like that. But if you have a trust and it's older than 2000, January 1st, 2020, not 20 years ago, this year, it changed January 1st, 2020, then you need an update. So we're contacting all our clients and having them come in for that or making arrangements for that. So we got Uncle Sam. I'm going to come back to that in a second. And then who gets the money? We've got the 3 kids. We've got Susie, Roger, and Danny. We'd love for Susie, Roger, and Danny each to get an equal share. Problem is, we're not so fond of Susie's husband, right? We're worried that we're going to give it to Susie, and then Susie is going to get divorced, or her husband's going to get his hands on it. Roger has some outstanding debt. Wouldn't it be great if we could get it to Roger and help him get back on his feet and not just have it go out to his outstanding debt? Danny's a little bit different situation. Danny's special needs. He was on Social Security, disabilities, SSI. Maybe he gets Medicaid. And the idea is if we leave him money, he will lose his medical benefits. He'll lose his disability. So wouldn't it be great if we could get it to Susie, Roger, and Danny and not have the idiot son-in-law, the creditors and predators, and have Danny lose his medical and disability benefits? Well, we can, right? So we can by using what we call lifetime protector trusts. So Susie's in charge of her share. She has complete control over it, but it's not, her husband can't get at it. A divorce judge can't get at it. Roger's creditors can't get at it. Susie, it's still divided 3 ways. Susie's in charge of her share, Roger's in charge of his share. Danny can't be in charge of his share. That's not allowed, where he could still keep his benefits. So we could put Susie or Roger or somebody else in charge of Danny's share. Okay, so it's an interesting option. A lot of lawyers don't include this type of planning in their planning. So just to know, this is an option to protect people, protect your kids. Okay, we're not controlling them, we're helping them protect themselves. They would still have control over the assets. Now let's talk about these retirement accounts. So I've been mentioning these throughout the hour here about these retirement accounts, and this is really important because this is brand new law, didn't exist before with regard to any kind of what they call qualified funds. That's going to be your qualified annuities, IRAs, 401ks, PSPs, TSPs, health savings accounts even. Anything where you put the money in and got a tax deduction for putting the money into it, right? Or an employer plan, like an employer plan. A Roth, when you put money in, you actually did pay the taxes on it to put it into the Roth, but you don't pay the taxes on the way out. Any of those things are considered tax preferred accounts. All of those are going to be affected by this Secure Act, okay? And so we've got 3 categories. We got that after you die, the taxes have to be paid within 5 years. That's the red. So we got red, yellow, and green, like stoplight, right? Red, 5 years. Well, if it's a decent amount of money, we might not paying a whole lot more taxes if we have to pay it within 5 years, especially if we're not clear about making sure that the money is paid. If we have different kids that are in different tax brackets, that's going to make a big difference too. Then we've got the 10-year, the yellow. Now, most people are going to fall into this yellow category. Well, that's why we need to update the legal documents to make sure that at least that you're going to qualify and that the kids are going to qualify in the yellow category, and they're not going to have to pay the taxes over 5 years. They're going to at least have 10 years to pay the taxes. But then there's all these different types of beneficiaries that we can actually even extend it beyond 10 years. So what we're doing for all our clients and any new clients is we're making sure that we incorporate every option. And you don't even have to make all these decisions. This is something that's going to be decided upon your death to say, okay, what's going to be the best answer to pay the least amount of taxes and allow the kids to get the most amount of money and the most benefits and protections. And so that's where we got the green, yellow, red. And it's very important in my mind that we incorporate this in your planning if you have any substantial amount, at least 100,000 or sometimes even less, but at least 100,000 in some kind of retirement account. An IRA, 401k, 403b, PSP, qualified annuities, any of those types of things. Okay, so very important. Finally, we have this asset protection trust. Now, this is not for everybody, okay? This is something we do for some clients, and it does avoid probate and handles things if you become disabled, but it also protects assets. Now, in order to get that extra protection, you also have to give up something. You have to give up some level of control. Not to me, not to the government, but to your kids. So now your kids have some control of your assets. Again, like I say, this is not for everybody. We have other ways of protecting assets for nursing home, protecting assets for Medicaid, protecting assets to qualify for different programs. But this is one way, okay? So since we're talking about wills and trusts, I wanted to throw it in there. So when it comes between the difference of wills and trusts, as you probably could tell, I tend to think that the trust is often going to be a more thorough and comprehensive answer. That doesn't mean that we don't still do plenty of will-based programs. But I put this graphic up there just to kind of show you, if we're going to do a will package, we're also still going to make sure that you have all the lifetime documents, that we have the subtrust as we need it. We have a trust-based package. It's still going to be comprehensive either way. It's just that one, we've got some probate issues on there. Option B is where it's more comprehensive. I look at the trust as being more thorough, more pre-planning, more comprehensive, but that doesn't mean that we don't do plenty of will-based plans also. There tends to be a little bit where it's age. Younger people tend to want to do this because it's a little less expensive. Older people say, hey, we're closer, we can see the value of this, it's going to save us money in the long run or the short run, it's going to save us often lots and lots of money to do the trust option, but it costs more now, right? It costs more today to set up the trust option than the will option. So sometimes younger people are more inclined to do that. And then sometimes with people with just, specific types of assets, it could be that there's a lot more money, but just because of the types of assets, this might be a more appropriate answer. But that's what lawyers are for. That's why we're not going to just, punch a hole. And this is why it's not just a form-based, situation. We're going to give you advice. You can pick from our advice, but we're going to, set it up which is going to be whichever you choose. We're going to set it up the best that it can be under those circumstances. And that's the key on this is these aren't just forms. I know people think that they are, and they're not. And I've seen, I rarely see somebody that tries to get forms and fill them out that it ends up actually completing their wishes. It doesn't mean that the form's not going to work. I hear this on TV sometimes, or on the radio in particular. There's this website that people can get legal forms at, and they advertise, and Sammy Davis Jr. Had this form from this website, and I'm thinking, Sammy Davis Jr. had enough money, he could have afforded to do real good planning. Instead, he gets this dumb form from this website, and they said, and the judge said that the form was enforceable. Of course it's enforceable. It doesn't mean that it followed Sammy Davis Jr.'s wishes. And we also know that it was in court, and it was in court, and and there was a big fight about it, and his widow had to hire lawyers, and all of the other kids hired lawyers, and it was this big fight. And then eventually, after years of fighting about it, the judge said, yes, this form was enforceable. But what it doesn't answer is, did it actually follow Sammy Davis Jr.'s wishes? It worked. Did it work the way he wanted it to work? Did it actually accomplish his goals? I can almost guarantee you it did not. And so sometimes people think, oh, it's just a form. I can just fill in the form. Not, not if you care about your wishes being followed. Not if you care about you making it work the way that you want it to, get the results that you want. So that is my presentation. And let's see if we have any questions. Savannah, I'll have you kind of weigh in if we have any questions.
Yeah. Yep. So I don't see any questions now. So last call, if you do have a question, go ahead and throw that up there in the chat box for us.
So if I'll give you a second to write in any questions. One of the things, if you don't have planning with us and you'd like it reviewed, if you do have planning with us and you haven't come in for the updates regarding the retirement assets, then Savannah's going to talk to you about the way to get a hold of us and of course sort of pre-screen us. If you're not a client of ours, you'll get an opportunity to interview us to see if we're a good fit, and we get an opportunity to interview you to see if you're a good fit for us. And my encouraging to you is to do it now, not to do it tomorrow or later or next. You do it now. I see that we do have one question. Is the Lifetime Protector Trust the same as an irrevocable trust? No, absolutely not. So Lifetime Protector Trust is for the kids. The irrevocable trust is for you. So the irrevocable trust, where you give up some control for some more security, some more protection. You give up a level of control, but you get more protection from nursing home. The Lifetime Protector Trust, on the other hand, is to protect the kids. Now that gives them more flexibility than the irrevocable trust would for you. So one is Lifetime Protector Trust is for the kids. Irrevocable trust would be for you if it's appropriate and suits your needs. Lifetime Protector Trust have really very few drawbacks to them. The ones for the kids are really kind of neat because they really have very little drawback, whereas the irrevocable trust for you, they do have some drawback, and that's where we have to discuss it and see if it's appropriate. All right, so I think we've answered the questions here. So we'll go ahead and have Savannah take over and talk about how we can have you get an appointment set up with us.
Thanks, Bob, and thanks for everyone for joining us today. Now, as Bob mentioned, we do have an easy way for you to get in touch with our team. If you think that you would like to meet with an attorney, or maybe if you just have questions and wonder, do I really need an estate plan? I don't know. I just want to talk about it. That's great. That's what we're here for. So you should have an email that arrived in your inbox in maybe the last 5 or 10 minutes. If you open that email, there'll be a nice red button there for you to click. You click that button, it'll take you to a calendar. You'll choose a day and a time that works for you when a member of our team can reach out and give you a call. There's no cost to this call. There's no risk. There's no obligation to sign up with us for anything. The call should last about 15 minutes, and it'll give you a chance to ask questions about our firm, about our process, and it'll give us a chance to ask questions about your situation, and just make sure that this is the right step for you. So I encourage you to go ahead and check your email. That should be there for you, and just reach out, schedule that call, and we'll get started working with you. Now, also remember that you will get the replay of today's webinar in your inbox tomorrow, so be sure to rewatch and share with family and friends. Thanks again for joining, and we will see you next week.